Good morning and aloha to everyone. Thank you for joining us today for the 2021 Statewide Homeless Awareness Conference. And a special thank you to Scott Morishige and the Governor's Coordinator on Homelessness for that wonderful video to start us off with a real positive note today. I will be your moderator for our plenary session this morning. And I would like to introduce Maud Cumming and Heather Lusk as our conference hosts for the 2021 Statewide Homeless Conference. Maud Cumming is the Executive Director of the Family Life Center of Maui and is the current chair of Bridging the Gap, the Balance of State Continuum of Care. The Family Life Center provides services which include crisis intervention, transportation, food and clothing distribution, and links to healthcare, mental health services, and housing services. Maud has spent more than 20 years working with those on Maui experiencing homelessness, and she looks forward to the day when she can work herself out of a job. Maud says that she does this work because it is a privilege to serve. Heather Lusk is the Executive Director of the Hawaii Health and Harm Reduction Center, which works to reduce harm, promote healthcare, create wellness, and fight stigma in Hawaii and the Pacific. Heather also has over 20 years of experience dedicated to reducing health disparities and stigma as it relates to HIV, viral hepatitis, and other chronic conditions linked to substance use and homelessness. And Heather is the current chair of Oahu's Continuum of Care. And here is Maud to start us off for the day.
Hi, can you hear me?
Yep.
All right. Greetings from your colleagues on the neighbor islands, the Big Island, Maui County, and Kauai. It seems like quite a while since I've seen all of you. We don't travel very much, and so it's great to see and hear and talk to you. And I'm happy to report that there have been many successful efforts on all of the islands as our service providers have been solidifying and increasing their services. During this pandemic, we have all had to pivot and be prepared to adjust our services. And while we have had our challenges, the numbers of people that we are serving has not decreased. And more importantly, the numbers of people exiting to permanent housing have continued to increase. This has been a great time to evaluate all that we are doing and make adjustments when necessary and seek innovative ways to continue to do the work that we do. My hat's off to all the access points especially, including outreach and shelters who have been on the front lines, courageously serving and tirelessly working despite all the challenges. And so to all of you, continue to do your good work. And as Ian DeYoung always reminds us, it is a privilege to serve. Thank you, everybody. Aloha.
And now we turn over to Heather.
Mahalo, Maud. This morning, I woke up with just so much gratitude, and it's not just because of Thanksgiving next week. I'm grateful, I think we all are, to the Awareness Committee, spearheaded by Jerry, and bringing us all together again. Even though it's hard to be virtual, it's nice to see so many of our colleagues from across the islands and even some folks from the continent. Feeling also really grateful for all of the folks that supported us from the feds, Mark Chandler and HUD. You saw that beautiful video by Scott Morishige and him and Emma and the team at the Governor's Coordinator on Homelessness Office, and at the city and county with Director Crucky and the team. All of them through the pandemic really provided leadership and guidance. It's a very scary year and a half for all of us, but really the heroes are you all, and Maud said this better than I will. But homeless services never closed. And you all navigated both the personal concerns and worries about COVID, as well as the professional. But you know what, as a houseless system, we know about meeting basic needs, which is something that we all really stepped up and did when many other people closed doors or went home. We know about translating complex information to make sure that the people that were houseless and the most already vulnerable understood about COVID and the changes, and gave them PPE and everything they needed to try to navigate what was already a resource desert and even harder to get their basic needs met. But more than anything, we know how to empower both the folks we support and each other to support and counter the isolation. We know how to provide the connection, even in this physically isolated reality that COVID placed upon us. I echo what Maud said about the outreach workers out there on the front line, sometimes being the only people on the street, the shelter providers who showed up every day, scared sometimes because of their own risks or their own family's risks, and everybody in between, the back offices and everybody that worked hard to make sure that we would mitigate the impact of the biggest public health crisis of our generation on the community that's most vulnerable. As we head into 2022 and hopefully have continued reductions in COVID, many challenges are ahead of us, especially as we see the fallout from the past few years. And in fact, our plenary in just a moment will really be highlighting the evictions and many of the other challenges. But again, we are resilient and we are stronger together. So mahalo for all that you've done the past couple of years. And thank you for taking time today to be here, to lift up our community, to support each other, because we still got a lot of work ahead. Thank you so much. And Laura, back to you to introduce our panelists.
Great. Thank you, Heather and Maud, for that wonderful welcome. Now we are going to turn right into our first session of the day. Throughout all of these sessions, please feel free to put questions into the question area on your panel, and your moderators for each session will moderate those questions as they come in. With the COVID pandemic still in our midst, the need for people to have continued access to affordable housing is paramount. Prior to the end of the eviction moratorium earlier this year, there was a lot of preparation and work done to prevent large numbers of folks losing their housing due to evictions. Despite these plans, there are still many people that do not understand their rights and their responsibilities in these situations. We have three wonderful speakers here today to help us understand the rules around the eviction, mediation, and fair housing. To start off with, we've got Tracy Wilchin. Tracy is the Executive Director of the Mediation Center of the Pacific, a nonprofit corporation that assists over 7,000 people annually with the prevention and resolution of conflict. Tracy designs and develops dispute resolution programs that meet the needs of our community and conducts training on mediation, facilitation, and conflict resolution throughout Hawaii, the continental US, and the Asia Pacific region. She is a lecturer in law at the William S. Richardson School of Law, and she serves on the Administrative Pro Bono and Pro Bono Initiatives Committees for the Access to Justice Commission. She holds a JD from the William S. Richardson School of Law, an MS from the University of Hawaii, and a BS from Gonzaga University. Then we'll have Dan O'Mara, who is the managing attorney for the Housing and Consumer Unit at the Legal Aid Society of Hawaii. In residential landlord-tenant cases, legal aid represents tenants. Legal aid also has the state's oldest and largest nonprofit public interest law firm with offices statewide. Legal aid helps provide civil legal aid to the most vulnerable in our community. And then to finish it off, we've got David Chi, attorney at law, who was born and raised in Honolulu. He graduated with a Bachelor of Science in Civil Engineering from the University of Washington and earned his Juris Doctor from the University of Hawaii William S. Richardson School of Law. David started his practice in landlord-tenant law in 1992. With many years in the field, his primary practice is advising landlords on the law and resolving summary possession claims. And with that, we will turn it over to Tracy for the beginning of this presentation.
Thank you, Laura, and aloha, everyone. It is really an honor and pleasure to be here. I am going to share my screen and go through my slides. So, and Dan and David will talk more about the legal details of Act 57, which was implemented, as Laura said, to address the ending of the moratorium and to ideally prevent a large number of landlords and tenants ending up in the court system. And so under Act 57, when a landlord provides a notice to a tenant that they need to either pay the back rent that they owe or they're going to be required to move out and be evicted, that 15-day notice must be presented to the mediation center on the island where the tenant resides at the same time. Because in addition to providing the tenant with 15-day notice that if they don't pay, they will be evicted, the notice provides the tenant with the important information that they can mediate first. There are community mediation centers on every island, and I have their information up here. Both their dedicated, every center has a dedicated phone line for landlord tenant matters. And then we also have our websites, and the PowerPoints will be available to you. It might be a little bit easier if you go to, I have the link at the very bottom, Hawaii Gov HHFDC Assistance for Renters Emergency Rental Assistance, and they will have everybody's contact information up there. So that's another option to get all the contact information at once. But what's important for landlords, when you provide the notice to the tenant, you need to provide it to the community mediation center on the island where the tenant resides. When landlords provide the notice to the mediation centers, and some of them, like the Mediation Center of the Pacific, require you to upload the notice through our website with some additional information to make sure that the information is correct. Make sure that you have the contact information for the tenant. If you have multiple tenants, make sure that the notice you're uploading has the appropriate information for that particular tenant. And I say this because we have received everything, and then that delays the process of being able to reach out to the tenant and schedule a mediation session for landlord and tenant. Really important, landlords, when, and please get this information out to the community, when a landlord provides a notice to the mediation center, to let us know the primary language of the tenant. And that way, when we proactively reach out to them, we can reach out to them in the language that they are comfortable with. So it will make the whole process easier. It's important for the tenant to contact the mediation center once they receive a notice. The contact information for the mediation center will be on the notice that the tenant provides. Once the mediation center and the tenant are talking, then the client service specialist or the intake person will gather information from the tenant and schedule a mediation at a day and time that works for the tenant. Mediations are generally scheduled Monday through Friday, 8:30 a.m. to 5:00 p.m. There are some Saturday morning sessions available. Once that date is determined between the center and the tenant, the landlord will be notified, and they're notified by email. So it's important that the landlord check their junk email box to get those email notices. And I will also say that if the date that the mediation is scheduled doesn't work for the landlord, please immediately contact the mediation center and let them know so that a new date can be scheduled that will work for both landlord and tenant. And remember, if the tenant doesn't call the mediation center and schedule a mediation session within 15 days from the date of the notice, then the landlord can move forward with the eviction process. So it's really important for tenants to return the phone calls of the mediation centers, to be proactive in calling them to schedule the mediation. Once the mediation session is scheduled, then the landlord can't move forward with the eviction process for a full 30 days from the notice. So this really gives landlord and tenant time to get to the table, to have discussions and mediations, to reach agreements, ideally that will help the landlord recoup the funds, the PAC rent, and importantly, to keep the tenant housed in that residence. So again, just a reminder for landlords and tenants to check your junk email folders, because oftentimes notices go directly there. So you should always be checking your junk folder. Now, mediations are primarily scheduled via Zoom, and I'll talk about that in a little detail. So in order to participate, landlords and tenants need to have a desktop, a laptop, or a smartphone with a microphone and camera. And they also need internet access and sufficient bandwidth. So it's important, if you're working with tenants, to make sure to talk with them. Do they have this equipment? Have they tested it? They may need to go to an organization within their community to use their equipment. They can also use the mediation center's office and equipment. Each center has at least one dedicated room and equipment set up so that they can, a tenant or a landlord, can go to the office of the mediation center and use their equipment and have support from the staff. And then finally, if neither of these options work, you may be able to schedule an in-person mediation session. We recognize that everybody's not comfortable with technology or may not have a private place to participate in mediation. So we certainly make our offices available for that purpose. How to prepare for mediation. It's really important to make mediation as productive as possible to prepare. A key thing is to apply for rental assistance if you haven't done so. If you have applied for rental assistance and you don't know what the status of that is, check in and find out, because the more information tenants have to share with landlords and vice versa, the more likely they are to be able to reach an agreement. Talk with an attorney. Dan will be sharing information about legal aid, and certainly tenants are encouraged to reach out to legal aid, and landlords can reach out to private attorneys such as David. And think about potential outcomes in mediation. It's not just about, I want my rent back or I want the tenant out. It's about what other options are there? What are potential outcomes that would be beneficial to both landlord and tenant? Because this is a perspective we look at as mediators. So let me talk about how that mediation process works. First of all, it's important to know that mediation is confidential. So by that, I mean the mediator doesn't go out and talk about what they've heard. The mediator can't be subpoenaed to go to court if you do end up in court in an eviction process. So both landlords and tenants will be asked to sign a confidentiality agreement, and that will be sent electronically for signatures. So again, be checking your junk email folder for that confidentiality agreement to sign. Again, it's important an interpreter will be provided if English isn't the primary language of tenant or landlord. The session is scheduled for an hour and a half. Now, sometimes it doesn't take as much time. Sometimes landlords and tenants feel like they need some additional time, or maybe they need to go out and gather information. And we're certainly happy to schedule another session. And please remember, there is no cost to landlords or tenant for mediation for any part of this process. So we want you to take the time that you need to have productive discussions to help you reach agreements that work for both landlord and tenant. Lastly, generally, once you meet as landlord and tenant in the mediation session with the mediator, We generally have you meet together, whether it's in a virtual meeting room or face-to-face. Now, what's important is if a landlord or tenant isn't comfortable meeting together, they can let the mediation center know, and the mediator will respect that. So you'll start off in separate rooms, and the mediator will go back and forth, whether they're virtual rooms or whether they're in person. We want you to feel as comfortable as possible to have productive conversations. If you do start off together, please also know that after initial start to the mediation process, the mediator will move you into separate rooms and still go back and forth. But at some point in the mediation, they'll bring you together again. So again, landlord and tenant have the power to say, I'm not comfortable being together. I prefer staying in a room by myself and working with you privately, mediator, and we'll respect that. The next thing that mediators do is they ask lots of questions. Each person comes to mediation with one set idea. We want to help you think of a lot of ideas for resolution. And in order to do that, we ask lots of questions. We want to know what's going on in each of your lives. First and foremost, we're going to ask, have you applied for rental assistance? If yes, what happened? There's been a lot of confusion about rental assistance. Some tenants applied for rental assistance last year. Maybe they never heard back, so they gave up and never tried again. Or maybe they did get rental assistance, so they thought they couldn't apply again. So it's important to bring out this information. If they haven't applied, why not? Maybe it was too difficult. Maybe they couldn't get the landlord to provide the W-9. Maybe it was just too confusing. So we want to know that, because that could be a very important part of an agreement. We'll ask more questions. What's your current financial situation? Has it improved from last year? Tenants who lost their job or maybe had hour reductions may be in a different place now, where they could start doing a payment plan or paying some additional funds to the landlord while they apply for rental assistance. So bringing out this information helps mediators work with you to create the best strategies. Do they think their financial situation will change? And what are your future plans? Sometimes tenants let us know it's really important. We want to stay here. Our kids are in school and the school is close by, or our kids are familiar with this neighborhood, or we're really comfortable here and it's close to work. So we want to understand all of that to best assist you in the mediation. We ask the landlords lots of questions as well. What's important to them? Is it covering the lost rent or having the tenant move out? Sometimes landlords come to the table with a very strong position that they want the tenant to move out, but maybe they didn't really understand the tenant's situation. Maybe they didn't know that the tenant was working really hard to get rental assistance. Maybe they were just frustrated after this long amount of time. So we ask them, what was your relationship like with the tenant prior to COVID? If they had a good relationship and the tenant could get rental assistance or come up with a payment plan and be a good tenant, wouldn't that be important to consider in staying? And if they could recoup all their back rent, would they consider doing a new lease? Would they consider reducing the rent? So we ask lots of questions before we move into negotiating. Once we get that information, a mediator will help landlord and tenant negotiate an agreement. And again, it's going back and forth between tenant and landlord in their private rooms, talking with the mediator privately. Now, there's lots of different types of agreements that we've seen through mediation. It could be that the landlord and tenant agree to work together to apply for rental assistance. In particular, we've seen this happen a lot when neither of them had applied, or maybe they applied once and didn't know they could apply again. Maybe the tenant can come up with a payment plan now that they're in a different financial situation to cover back rent or a portion of it while they're waiting for rental assistance. I've seen a lot where the landlord and tenant agree to keep talking in the future as they move forward because they hadn't been talking before for a variety of reasons. Or maybe the landlord agrees to reducing the rent as they move forward. We have seen all of these different types of agreement and more. And remember, a mediation agreement will keep the landlord and tenant out of court and they can avoid the eviction process. Just to give you an idea of current data, from the current mediation program. So from August 7th to November 13th, just on Oahu alone, 858 cases were open, 322 cases were mediated, and 281 cases reached agreements. That's close to a 90% rate of agreement. And the neighbor islands have seen this high rate of agreement as well. So this process is really working. It's helping a lot of landlords and tenants be able to re-strengthen their relationships. And most importantly, it's helping tenants remain in their residence and helping landlords get the back rent that they've been owed. So just final reminders, remember, landlords must submit the 15-day notice to the mediation center on the island where the tenant resides. When a tenant receives the notice, they should call that mediation center immediately to schedule a mediation. Encourage tenants to participate. One of the challenges we've seen is tenants are reluctant to call, they're reluctant to participate, and it's so important to encourage them. Let the mediation center know the tenant's primary language so we can reach out to them. Reinforce the importance of calling immediately. And let the mediation center know if you cannot attend the mediation session. We've had a lot of tenants and landlords just not show up, and that can ruin their chance to participate. So please let us know if for whatever reason you're not going to be able to attend so we can reschedule the session for you. And lastly, remember, mediation can help build stronger relationships between landlord and tenant. And this is so important right now. Mediation is not like going to court at all. It's much less informal. And most important, it's the landlords and tenants making the decisions, not a judge. A mediated agreement will help you avoid court. And finally, it's a chance to create plans to avoid eviction. So thank you. And if you do have questions, please put them in the chat and I'm happy to address them.
Great, thank you, Tracy. And we're going to move over to Dan and David now. And just as you folks are getting your PowerPoint set up, we had one question, and you might be covering this, so just think about this while you're setting up. What about evictions of holdover tenants? A person rented a house and the rooms were sublet. The renter didn't pay rent, ran away, and abandoned the subtenants. So if you guys can possibly address that question through your presentation, that'd be great. And now I'll hand it over to Dan and David.
Okay, I'm going to save that one for David a little bit. I'm going to just go through a few things. I'm Dan O'Meara. I'm the housing managing attorney for our housing unit at Legal Aid. And so I'm going to talk about there's a difference in homeless the homeless environment and the landlord-tenant code and fair housing. I just want to sort of point that out to everybody. So the landlord-tenant code applies to, it does not apply to homeless facilities under Part 17 of Chapter 346. And so that might apply to some of the organizations here. So I want to show you what the landlord-tenant applies to. It applies to rental of dwelling units. It doesn't apply to hotels and motels. It doesn't apply to residences and fraternal organizations, homeless facilities, UH or HPHA, the Public Housing Authority. So landlord-tenant code is strictly about rental of dwelling units. The one that might apply to this group, and there's a lot of information here, so this presentation will be available after the conference. But the landlord-tenant code doesn't apply to, these are the types of organizations it doesn't apply to, that these Chapter 346, Part 17. So there's, which whenever we look at it, it's always kind of tricky to find out whether the landlord-tenant code applies or not. So for those of you to whom it's relevant, this information will be there as a resource. So that's the landlord-tenant code. So landlord-tenant code is residential tenants. Then you get into fair housing. And part of it is what is subject to the Fair Housing Act is that the Fair Housing Act is broader than the landlord-tenant code. So the Fair Housing Act applies to homeless shelters, the public housing authorities, private housing, supportive housing. So it includes, even if you're not subject to the landlord-tenant code, you could still be subject to the Fair Housing Act. And I guess that's why I want to make sure, because I know that we see people struggle with, well, I'm not subject to the landlord-tenant code, so I'm not subject to fair housing. But it doesn't quite work that way. It's landlord-tenant code is just a subpart of the Fair Housing Act, because the Fair Housing Act will include mortgage lenders. It includes anybody in the housing industry, and not just in the landlord-tenant code. It includes real estate agents and sales of homes and so forth. So I just want to make clear that fair housing is a bigger umbrella than the landlord-tenant code. So even if you don't think because of some exception, you're not subject to the landlord-tenant code, doesn't mean you're not subject to the Fair Housing Act. And as with respect to homelessness, we want to sort of accentuate what the protected classes are. You can see on the federal side what is a protected class, and then Hawaii has a different set of protected classes. You know, the Hanai status comes up actually fairly often for us with shelters or in Section 8. It comes up in a lot of different contexts as far as Hanai status, which is, you know, unique to Hawaii. This is a lot of information, but I wanted to point out that most of the complaints that HUD gets on fair housing, the single biggest category, the one that says 43%, is failure to make reasonable accommodations. So that has to do with people with disabilities. And so overall, there's 73% of the complaints deal with different terms and conditions, like I'm not going to rent to you because you have kids, or I don't understand you, so I'm not going to rent to you. As a general category, that's a catch-all for all the protected classes. But the single protected class that is subject to the most HUD complaints is disability, which relates to reasonable accommodation requests. So for purposes of this group, I think some of the relevance is that one of the ones we see as an organization is discrimination based on national origin, which manifests itself by language access. So if you have a COFA community member who speaks Chuukese, if you are funded by the state or the federal, there's probably an obligation on your part to provide language access to be able to communicate with that person in their language. And a lot of organizations are obviously aware of this, but it's one that pops up because sometimes it's hard. You know, somebody at the interaction level with somebody who's coming into their housing situation, and they don't quite understand what's going on, and they don't quite have the capacity to go get an interpreter. It just is it's an ongoing challenge for everybody, and anybody who's getting state or federal funding is subject to that type of protection for people based on their national origin and their language. The other one that comes up is domestic violence. The Violence Against Women Act is a federal law. It applies to federally funded housing or assisted housing. So it applies to pretty much most programs that get any sort of federal funding, which can include Section 8 landlords are subject to the VAWA. Public housing is subject to it. If you're a shelter and you're getting federal funds, you're going to be subject to Violence Against Women Act. And what that does is domestic violence itself is not a protected class per se, but because women are 3 times more likely to be victims of domestic violence, discrimination based on domestic violence manifests itself as discrimination based on sex. And that's how VAWA comes into this. And it comes up in a lot of different contexts too, because it can include stalking. So it doesn't have to be necessarily an intimate relationship. It can be some person who's stalking you, and that can be, you know, basically you're subjected to domestic violence in that circumstance. So that's the federal side. The state side, under the landlord-tenant code, it provides some protection for domestic violence, and I've put up the statutes here that apply to it. It allows a person, a man or a woman, who is subject to domestic violence to be able to terminate their lease. They can terminate it early. It has requirements that there must have been some sort of evidence of it, like a TRO or a police report something that would demonstrate that there was domestic violence. It allows that person who was subjected to the domestic violence to be able to leave their tenancy and not have to pay anymore. It also, if it's a Section 8 voucher that the person has, then that person can bifurcate. That person who's the subject of the domestic violence can kick the other person off of the voucher and maintain the voucher themselves. So that's kind of a melding of the Landlord Tenant Code and the Violence Against Women Act together. So the state law protection strictly under the Landlord Tenant Code is in these sections that are cited here, and a way for people who are subject to domestic violence to have recourse. And the big one that we already mentioned is disability. It comes up in a lot of different contexts. We see it in many, many different contexts. And somebody who has a disability is somebody who has a physical or mental impairment that substantially limits one or more of their major life activities. So somebody who has a disability is entitled to seek an accommodation to be able to have the same chance to have a living situation as anybody who didn't have that disability. So this comes up a lot of different ways, and it comes in apparent in ways that you can't know. You know, somebody who has limited mobility may have a wheelchair or may have something else. You might have somebody who has anxiety and PTSD. And I'm guessing that as a group, this audience is familiar with people with these issues, and they manifest themselves in a lot of different ways. You know, maybe it's inability to sort of follow rules, or it might be, you know, some of these things manifest themselves like in hoarding. We've seen it in context of people who, well, they might need an assistance animal because of their anxiety, or like in the case of the diabetes, you know, there's some service dogs that actually help sense certain medical conditions and can alert people. So disabilities can be a lot of different things, but it's a very important, I guess, for lack of a better word, I'm going to say it's an important tool for people with housing who have disabilities. It can manifest itself because they might live in a property where they aren't able to get access, and so they can try and ask for an accommodation to get the access or a parking space. It can manifest itself in maybe you need parking. Maybe you need, and this comes up not infrequently, is you might need a live-in aid for somebody with a disability might need a live-in aid, so they need an accommodation to allow that person to be there to assist them. So that the reasonable accommodation is an important tool to help people with disabilities maintain their housing and maintain their housing in a way that provides dignity and access to them also. Then you have modifications. So modifications are something that you need. Maybe you need a ramp. You might need a different type of tub or shower. You're entitled to ask for those things, and then it just depends on what type of housing you're in as to who has to pay for it. So if it's just a private landlord-tenant situation and you need a grab bar or you need a ramp, it might be, it's not necessarily the case, but it might be that the person who needs the modification would have to pay for it. And in some instances, like if it's a grab bar, for instance, it might be that when you leave that unit, you might have to take the grab bar down. But that's sort of a case-by-case basis, which is why we're here too, to help advise in that regard. But if you've gotten certain types of federal funding, then those modifications are paid for by the housing provider. And there's lots of examples of that. Certain types of, I list, it's called 504 and ADA. If a project has that type of funding, then the housing provider is the one who is obligated to pay for those modifications. And again, reasonable is always the qualifier to that. You know, it might be that you're entitled to a ramp and access, accessible door so you can don't have to pull it open, but that doesn't necessarily mean that you're entitled to an elevator that's earmarked just for your purposes. So reasonable has a component in it, but depending on the type of funding you have for your housing provider, then it gets into who has to pay and what sort of modifications are reasonable. And then when you make those requests, and this is one where we see people stumble occasionally, it can be done in any time, any manner, orally or in writing. So a lot of times people are asking for an accommodation without saying it's an accommodation. Saying, well, I can't get in, I need some help with this door, or this door shuts too quickly. Even though they're not using, there's not magic words. I guess that's the way to say it. There's not magic words that would say you're asking for accommodation. If somebody has a disability, if they're asking for that type of assistance, that's basically asking for an accommodation. If depending on the type of disability, they need to provide some sort of professional opinion that request for the accommodation correlates with and is a nexus between that and their disability and what they're asking for. So there has to be a connection between what they're asking for and what their disability is. And some housing providers want to insist on their own form. It's not required under the Federal Act, so it's kind of a challenge for people sometimes with accommodations. And as an organization, Legal Aid has a fair housing enforcement group. We generally, we know that assistance animals are hot button topics for a lot of people. And so we generally aren't satisfied with the internet type of verification. That's not to say it might not be appropriate in some circumstances, but as an organization, we tend to, if we work on an accommodation, we tend to want to be able to speak with the provider and make sure that we're on the same page as what the accommodation is needed. And then this is kind of a big one too, is this is the end for me until David joins here, is that Legal Aid also will provide technical assistance for fair housing questions. And that's our email address, which is in this. And I'm going to actually, because it's this group, I'm going to ask this question of you, because one of the things we find in helping tenants right now with rental assistance or even mediation is that they aren't able to communicate. And the reason they're not able to communicate, or we're not able to communicate with them, is simply because they don't have a phone. And so, I mean, there's several instances where we can't reach somebody, the rental assistance provider can't reach somebody. It's because maybe they're homeless right now and they don't have access to a phone, or they've lost their phone. So we kind of keep looking for it. And if anybody has those suggestions, by all means, email us if there's ways to provide phones for people who need it, especially now when they're going through evictions or going through some rental assistance. So that's just a request I'm making out there, just because as an organization, we run across that, and being able to communicate is a big deal. And I'll stop there. And
Great. Thank you. Thank you so much, Dan. Just before David starts, because I want to give him as much time as possible, I just want to read through a couple of the questions that we've got in case you're going to be able to touch on them in your presentation. So one question is, what about issues arising out of overcrowding? Registered tenants sometimes run into problems with landlords because of other family members or friends staying with them without being registered on the lease. Sometimes this kind of issue triggers the eviction process. Could the mediation process be effective with this kind of problem? Then the next question, can the owner of a house that was sublet to a person with a disability initiate eviction if the person who sublet the house abandons the subtenants? And then the last one is, what can we do when a foster parent threatens to kick out an 18-year-old with disabilities, such as a mental illness? So with that, I'll turn it over to David, and then the speakers can either respond in the chat or talk about it in their presentation. And over to you, David.
Well, thanks. I'm David G. I represent landlords typically, and I'm very happy to be with all of you today. I wanted to kind of bring things back to avoiding evictions. I imagine that most of you are involved with folks who either are homeless or are about to become homeless. And it seems to me that the best way to solve somebody's homelessness problem is to not let them become homeless to begin with. So if they are already in a rental agreement and the landlord is threatening to kick them out, or if the landlord is actively moving forward with a plan towards eviction, then there's a couple of things that I would think that you would want to know. First thing is that, all the information that Dan just gave about fair housing, all of that's really useful to know. I mean, if you're running across a landlord who's decided, well, you're blind and your tapping of the cane is making too much noise, and so that's why we're evicting you. That's something that you might want to keep in mind, because in all likelihood, it's not going to be a very legitimate basis for terminating a tenancy. But one thing I wanted to address sort of at the beginning is that if you are helping out a tenant who is trying to save their tenancy, one thing that you have to keep in mind, and I know that this goes contrary to every Broadway musical, every movie that you've ever seen, but landlords are generally not evil. Landlords are generally not the tenant's enemy. They are involved in a business where each needs the other. The landlord provides a property and services, and the tenant provides the money for the landlord to continue to do that. And so they need each other. And it's just like anything else, when one stops working, when one stops performing, the other one is going to get upset. So, and that's really what you get when you get landlord-tenant eviction matters is, generally speaking, it's the landlord has decided or has come to the conclusion that the tenant has ceased to do what it is that they need to do. Now, generally speaking, something like 90% of all the cases that I've ever seen, maybe more than 90%, are about non-payment. So that's the vast majority of cases that are out there that are happening. And so when you are looking at a non-payment situation, Act 57 was implemented by the legislature and signed by the governor, so that as we are coming out of the effects of the pandemic, that instead of going about business as usual and doing evictions straight up as soon as somebody hasn't paid the rent, Act 57 requires mediation. So when you're going into mediation, there's a couple of things that I think you ought to understand, especially if you are trying to assist a tenant who is in danger of losing their home. And the reason that I'm telling you this is that most people have never been through mediation before. I've got lots of clients who've got lots of units and they've never been through mediation before. So the understanding what's supposed to be happening in the mediation, I think Tracy covered that really well. But I think that part that you wouldn't understand is, or perhaps hadn't given too much thought to, is what the landlord is trying to achieve in a mediation. And obviously, one of the stated goal of any type of eviction action is that the tenant would have to leave the apartment or the unit. But the honest truth is that that's not usually what the landlord really wants. When I started doing this work, 20 odd years ago, landlords would ask me to evict people, and I would say, okay, and we would go through the process, and I would get the eviction done, and then I would get the place back for the landlord. But at some point, I realized that landlords don't really want to evict people. What they really want is they want to have the problem that they're having with the tenant solved. That's what they really want. Okay. Landlords generally do not want to lose their tenants because getting a tenant is an expensive process. They have to find, they have to advertise for the tenant. They have to vet the tenant. They have to go through all all the processes to make sure that the tenant is a good tenant for the landlord, and then, you know, sign up rental agreements and all that other good stuff. That takes time, that takes money. And so that's like an investment that the landlord is making in the tenant. And so generally speaking, landlords are not interested in finding, you know, incurring those costs again and finding another tenant. They would much rather solve the problems that they're having with the existing tenant than they would to go find another one. The other thing that you should consider is that if a landlord is successful in having the tenant removed, the landlord then has a whole bunch of costs. You know, for example, legal fees. They have to pay the attorney to go and, you know, have the eviction done. Then when they get the unit back, they have to repair the unit. So they have to, you know, pay contractors to come in, make the repairs. And all of that takes time. And all the time that the unit is down, they're not collecting any rent. And then, you know, they got to go find another tenant. So you have to keep in mind that a landlord actually has a built-in incentive to try to keep the tenants. So in the non-payment context, I'm going to suggest to you that when you're going into a mediation or trying to assist somebody with a mediation, that you consider that what it is that the landlord really wants is, in all likelihood, to try to keep the tenant, but to figure out some way to get everything paid off. You know, that's what they want to do. They want to solve the problem, get the money paid off. And we're living in this unprecedented times, as they keep saying, but it really is. I mean, there's huge amounts of federal money available to help pay off the back rent. If people are not taking advantage of that, it's a monumental, you know, miss. So to the extent that you're working with somebody who hasn't paid the rent, that really ought to be, you know, job one, is get them to apply for rental assistance. Let's see, what else did I want to tell you? Primarily, you know, the message that I wanted to leave you with is to know that you should not be approaching any type of a landlord-tenant relationship with the thought that one of them is evil and one of them is good. You know, you're trying to help people to save their housing, and basically it's like, you know, somebody who's threatening divorce. What you really want to do is save that relationship. Okay. And there's other things you can do besides simply paying everything off. In some instances, there's no hope. You know, there's just no way that the money is ever going to come together to get everything paid off. I mean, and in those instances, there are different options that you should consider. For example, there's one that I like to call stopping the bleeding, which is, you know, perhaps the tenant doesn't have enough money to pay off that $30,000 of back rent, but maybe they have enough money that they can pay the rent going forward. And what they really need is some time to find a new place and to move out. And in those instances, you know, one possible solution is to have the tenant pay the rent as it's coming due for, say, the next 3 months, and in exchange for the landlord waiting for 3 months before they remove the tenant. Anyway, there's a lot of different things that you can do to be creative to assist people so that they can avoid becoming homeless. And anyway, that's all I had to say.
That's more than enough, David. That's fabulous. I think that my biggest takeaway is landlords are not the enemy. We all want the same thing, to keep people housed, maybe for different reasons. They have their assets to protect and to pay for, and we have people that want to stay in housing. So just to try and get some of these questions in the last couple of minutes, we have a question. Can Legal Aid or Mediation Center of the Pacific provide services to assist a tenant in having a conversation with the landlord prior to eviction case going to court? This would be in a situation not related to Act 57 and not limited only to evictions for non-payment. If you engage prior to the case going to court, this may save the landlord attorney's fees and court costs. That's to Tracy. Tracy, do you have a response for that?
Yeah, absolutely. And yes, we can provide mediation, and we would encourage it for that situation. So contact the Mediation Center of the Pacific either landlord or tenant, and we can get your information. We can reach out to the other person and schedule mediation. Again, even though it's not the Act 57 program, there'll be no cost for landlord or tenant. We'd be happy to work with you, and we encourage you to be proactive and mediate early.
Great, thank you, Tracy. I knew that was the answer. All right, what about refusing housing due to an emotional support animal? Not a service animal, but an emotional support animal to help with mental illness, depression, anxiety. Dan or David, do you have any responses for that?
Oh, yes. If you're basing it basically that you have a no pet policy and you're saying you don't want the emotional support animal because you have no pet policy, well, under the Fair Housing Act, emotional support animals are just not considered pets. So you cannot base a decision on the fact that they have an emotional support animal. And actually, if you do and you decline it because of that, that has gotten more than one person in trouble, I guess, for lack of a better word. So not a good practice. Not a good practice.
And I would agree with Dan. I think that the only caveat that I would have is that the person's got to have an actual disability. So if, like, I mean, who doesn't have some degree of anxiety these days, right? But the real question is whether or not that depression and anxiety arises to the level of a actual disability. And if it does, then, a reasonable accommodation is required.
Great, thank you.
And most people who have an emotional support animal will have some sort of verification. That's why I talked about online versus not, but that there's got to be that connection. So absolutely.
Great, thank you. All right, and we'll go back to some of the other questions just in case somebody does have an answer. What can we do when a foster parent threatens to kick out an 18-year-old with disabilities, such as mental illness?
I was responding to that, and I don't know. That's just tough because it's probably not strictly a housing issue. You're getting into a whole world of, it's not an eviction, not a landlord-tenant relationship, probably. So that's probably, if it's a foster child, you're probably going to implicate the state in some fashion, which maybe this group is probably more adequate to deal with.
Yeah, and I would also say maybe adult protective services, as well as like child welfare services. All right. Can the owner of a house that was sublet to a person with a disability initiate eviction if the person who sublet the house abandoned the subtenant? These are two questions about subleasing, and that's not sure where that comes in, Tracy, with the mediation or with the legal basis for those sublet renters.
I can take a stab at that one. Generally speaking, if the landlord tenant code only applies if there's a rental agreement between the parties. So if the actual tenant, the landlord rented to the tenant and then the tenant sublet to a bunch of other people, if the relationship is severed between the landlord and the actual tenant, then the subtenants don't have any rights that are anything more than what the original tenant had. So if the original tenant, tells the landlord, hey, I'm going to terminate this tenancy in 28 days, the subtenants don't have any rights that are greater than the tenant's rights.
Okay. And I think I would also add to that possibly, and Tracy, you can correct me if I'm wrong, but that might be an opportunity for those subleasing people to have that conversation with the landlord to possibly take over, and that might fall into a possible mediation possibility, Tracy?
Yeah, absolutely, Laura. I would completely agree with you. And actually, we're seeing a lot of those types of situations right now. And the key is, coming together and talking with the assistance of a mediator to see what kind of agreements you can work out.
All right, and then the last one, can landlords evict a tenant because they want to turn the rental unit into an Airbnb? I think that has a lot to do with whether or not it's a permitted Airbnb. But if anybody would like to add on to that.
I'll answer that one. It doesn't really matter why the landlord wants to, I mean, they might want to evict a tenant because they want to, use the unit to store their pets, whatever the reason is. Really, the question is whether or not the landlord, it's not so much about the what the landlord wants to do with the property, so much as it is whether or not the existing rental agreement is such that the landlord has the option to do that. So, for example, in any month-to-month tenancy, a landlord generally has the ability to terminate that tenancy by giving a 45-day notice for any reason or for no reason, as long as that reason isn't discriminatory or retaliatory.
Great. All right, we have one more question and then we're going to close this session. Can a tenant be evicted if they pay their rent each month, but due to Social Security coming on the third Wednesday or similar problems with work income, they pay the landlord either some at the beginning of the month and the rent later, or all at the middle or later in the month? So I guess it's a question about if they don't have enough funds at the very beginning of the month, what can they do? What can they do with the landlord?
Hey, Dan, you want to tackle the part about like Social Security or
Yeah,
what do you handle that part?
I think one, just a practical part is they might incur a late fee, right? So if there's no real good reason, it's just the timing. But if their income is somehow disability related, which it often is, or if there is a disability, you can ask for an accommodation. We've done this with landlords. Just say, listen, here's when my money comes in, here's how my source is, and I need an accommodation so I can pay on the 15th or whatever, and just sort of do some sort of modification to the lease. That's probably the way to handle it. And we're happy to engage with those because, it's fact specific.
Yeah.
With respect, though, to, let's say somebody gets paid on the 10th of every month, and that's their payday, and they don't have any money to pay the rent until the 10th, and there's no disability or other things involved, then if they don't pay their rent on time, they can expect that eventually these late fees will add up, and I'm not aware of any legal protection that they're provided from eviction if they don't pay their rent.
Yeah. I think the bottom line in all of this, and I'm sure you all will agree, is it's better to talk sooner than later with your landlord, and to make these accommodations as workable for both the tenant and the landlord as possible. And don't ignore calls from the landlord. I think that's the biggest thing in this. You always expect if the landlord's going to call, it's bad news, but that's not the case. And so more communication is better than none. And so with that, I want to thank Tracy, Dan, and David for their expertise in this session. And I want to thank all attendees. We had almost 400 attendees on this session. So hopefully you all got some great information out of this, and you have new experts that you can reach out to. And now I want to invite you all to go into your next session. It will begin at 10:15 on the dot. You have 4 choices for your next session: human trafficking on homeless, mental health and homelessness, rental relief, emergency rental assistance, and homelessness among children. So you've got lots of options, but please remember, all of these sessions will be recorded, and we would really appreciate all of you filling out evaluations. And keep in mind, if you are planning on collecting CEUs from this conference, that you will have to have filled out conference evaluations on those sessions. So with that, thank you to our guest speakers, and everybody else. Have a wonderful day, and please join us for the next several sessions. Have a great one.